gotta stay out of my head. Stuck between my rights and my wrongs. Second guessing what I'm doing. Like, am I really there for my boy? Not enough, but if I'm paying child support, do that make it for time that I've lost? Whole time paying this court system. Can't even call my little man a game system, cause my checks be short. And if your bag too short, well, you had to miss a month. Slipping up, I gotta pick it up. Grind limitless, but it got your folks like, yeah, I hope you don't get caught. Like I missed them payments on purpose. Cause you see I fail and I'm hurting. Ain't had no job, so no working. Or the job I work is not working.
Shalom, this is your Ark, Yah is magnified, coming back with another informative video. I titled this video, James Frederick Williams, 42 U.S.C. 1983 Federal Lawsuit, Part 1. But before I tackle this subject, as always, I must state for the record, I'm not a lawyer, I do not practice law, and I do not pretend to. All my videos are for informational and educational purposes only. They're all facts and all truth. Nothing more, nothing less. So with that being said, let's get to it. Okay, guys, so as you all know, I promise you all that I will be doing this case right here. Why? Because James Frederick Williams went on the Fraud and Law channel and talked a lot of trash about me. He don't even know me, you know. And I'm the only one on YouTube showing proof as always, okay? But as you also know, they came on this channel talking as if they have won the victory already. But like the old saying goes, man, never count your eggs before they hatch, especially if you know what I know, okay? I know for a fact, not to be the bearer of bad news, but the truth is the truth and the facts is the facts, that James Frederick Williams will lose this federal lawsuit. Why? The reason is simple. For one, he's bringing it into a court that does not have jurisdiction to hear the matter. For two, all the plaintiffs are immune underneath the 11th Amendment sovereign immunity, okay? And for three, he went with someone who doesn't have understanding of what they're doing themselves, and that person that he went to is in fact still on child support and never won a child support case a day in his life. So those are the three basic reasons that I can give you all of why he's going to lose, okay? And it's just that simple. But now that you all can see, this is the boilerplate template that Osiris gave his client, James Frederick Williams. Okay? We're going to go over this template so we can get a better understanding of what he's filing into the court and this nonsense that he's putting on the federal record. Alright? So now, as you all can see, this document was filed April 10th, 2018. It was filed in the United States District Court, Middle District of Tennessee at Nashville. Okay? We see the plaintiff. The plaintiff is James Frederick of the family Williams, the injured party. We all, like I said, man, we all know who does that of the family nonsense. The stuff never works in no courts, no state courts, no federal courts. It just doesn't work, period. He's going up against the 42 U.S.C. subsection 654-3 Child Support Division, Hamilton County, Tennessee, Hamilton County Sheriff Department, 4D Contractor, Hamilton County Clerk of Court Division, 4D Contractor Audrey Jones, 4D Contractor Chris Gotti, Case Manager Stacey Elrod, Corrections Corporations of America, and then he has Maximus Child Services. Those are all the defendants, right? And he's suing each and every one of them underneath 42 U.S.C. subsection 1983, deprivations of rights under color of law. Okay? So if he's suing them more than 1983, but each and every one of these defendants right here on down are immune from suit according to the 11th Amendment in federal court. All right? Especially underneath a domestic relations issue such as this one that the plaintiff is complaining about. So let's pick this up at 1 where it says preliminary statement. It states preliminary statement comes now. James Frederick of the family Williams, who moved the court for entry of judgment in his favor because the defendant deprived him of his life, liberty, and property without due process of law, and while under contract deliberately and with premeditation subject him to the deprivation of his rights, privileges, and immunities secured by the Constitution and laws. Then it has the case law right there. I guess he's supposed to be quoting the case law behind it. Let's read it. It says the court is to protect against any encroachment of constitutionally secured liberties. Williams brings this suit under 42 U.S.C. subsection 1983 for violation of his rights under the United States Constitution and Tennessee state law and seeks declaratory relief and damages. Okay, this is page 1. Let's go to part 2, which is jurisdiction. This court has jurisdiction over plaintiff claims pursuant to 28 U.S.C. subsection 1331 and pursuant to 28 U.S.C. subsection 1343A and A4. This court has supplemental jurisdiction of the Tennessee state laws claims pursuant to 28 U.S.C. subsection 1367. Then he goes over venue. Let's pick this up at venue 3. Venue in this court is proper as to all defendants pursuant to 28 U.S.C. subsection 1391A2 and B2 because the events giving rise to the claims occurred within this district. Okay, let's continue. 4. The parties, it states injured parties, James Frederick of the family Williams, the adult male of the human species above the age of puberty, created by the creator of the universe, Genesis 1:26. See preamble. Born equally, free, and independent, not subject to the legal constraints of another, unconstrained, having power to follow the dictates of his own will, not subject to control, restriction, modification, or limitations from a given outside source, possessing inalienable inherent rights, among which are enjoying and defending his life and liberty, acquiring, possessing, protecting property and reputation, and seeking and obtaining happiness and safety. Okay, that was from the plaintiff, which was the first party. Now let's go to the defendants. You say it states defendants. The 42 U.S.C. subsection 654.3 single and separate child support division, 31 U.S.C. subsection 6305 contractually concealed in the executive branch in a partnership with the federal O.C.S.E. and employers to 45 CFR subsection 302.34 for the contractors within the county to advertise offers and sell 4D services to customers as a condition of receiving billions in federal profits, subject to 42 U.S.C. subsection 1983, always relevant to this lawsuit. Okay, so as we see, he's bringing this claim against the 42 U.S.C. 654.3 single and separate child support division underneath 42 U.S.C. subsection 1983. Okay, so let's continue. Defendant Hamilton County Sheriff Department, organized under the Constitution of Tennessee, subject to 42 U.S.C. subsection 1983, always relevant to this lawsuit under 45 CFR subsection 302.34, contracted with the 42 U.S.C. 654.3 to provide service of process warrants for arrest that targets only individuals subject to 4D activities in return for payments from the CSD. Okay, but again, he's bringing it against Hamilton County Sheriff Department as what? 42 U.S.C. subsection 1983. Okay, let's continue on. That's page 2. Let's go to page. Defendant Hamilton County Incorporated as a municipal corporation is advertise offers and sales 4D services to customers and perform administrative duties of the 42 U.S.C. 654.3 that target only individuals subject to 4D activities in return for payment from the CSD. Defendant Hamilton County Clerk of Court Division, organized under the Constitution of Tennessee, subject to 42 U.S.C. subsection 1983, always relevant to this lawsuit under a 45 CFR subsection 302.34 contract with the DCS to provide the duties of a clerk of court that are purchased and initiated by CSD that target only individuals subject to 4D activities in return for payment from the CSD. Defendant Magistrate R.G. Jones, subject to 42 U.S.C. subsection 1983, always relevant to this complaint, signed arrest warrants without probable cause and conducted court hearings, purchased and initiated by the CSD in compliance with PL number 93-647 under a 45 CFR subsection 302.34 contract to provide magistrate services that target only individuals subject to 4D activities in return for payments from CSD. Then it states defendant Chris Gotti, subject to 42 U.S.C. subsection 1983, always relevant to this complaint, signed arrest warrants without probable cause and conducted court hearings, purchased and initiated by the CSD in compliance with PL number 93-647 under a 45 CFR 302.34 contract to provide magistrate services that target only individuals subject to 4D activities in return for payment from the CSD. Again, case manager CSD Stacy Elrod, subject to 42 U.S.C. subsection 1983. Always relevant to this complaint is 4D's agencies personnel performing 4D enforcement functions that target only individuals subject to 4D activities in return for payments from the CSD. Defendant, Corrections Corporations of America, subject to 42 U.S.C. subsection 1983, always relevant to this complaint, a full-service private correction management provider and the fifth largest private correction system in the nation, hold managed secure bids under contract with government partners, local and state trades under the ticker symbol CXW in the New York Stock Exchange. CCA, Silverdale is under. Okay, this page 3. Let's go to page 4, guys. Contract to provide services that enforce coercive incarceration that target only individuals that subject to 4D activities in return for payment from the CSD. Defendant, Maximus Child Services, Inc., 42 U.S.C. Subsection 1983, always relevant to this complaint, under corporate citizenship, is partner to defendants, providing jail services that target only individuals subject to 4D activities in return for payments from the CSD. Okay, guys, so as you all can see, this had everything to do with child support services, all right? So since all the defendants had to do with child support, and as you all can see, he clearly explained that they all are acting in their scope of duty, this case will be thrown out. Why? Because you cannot bring a 1983 claim against an individual who's acting underneath their scope of duty. And it's just that simple. That makes them immune from suit. Okay? He has to prove how they not acting in their scope of duty in order to have this federal lawsuit passed, which he have not done so far. He simply justified that they are doing their contractual duties, or they're working their duties as an employer of the state, which means that they are also immune underneath sovereign immunity. Okay? So now let's go over the defendants. It say V, defendants defined. It states defendant are within the meaning of 42 U.S.C. subsection 2000 EA. Now hold on. Let's read that one more time. It states defendants are within the meaning of 42 U.S.C. subsection EA. Now, if he's bringing this claim underneath, let's go up, subsection 1983, then why didn't he quote the definition for defendant underneath 42 U.S.C. 1983? Because he know, like I know, these defendants under 42 U.S.C. 1983 are immune from suit. Why? Because they're acting in their scope of duty. Okay, but let's continue reading though. Let's continue, keep going over this nonsense on the screen, just to show you all how he's going to lose and why he will lose. It states defendant are within the meanings of 42 U.S.C. subsection 2000 EA. Definition of person. A. The term person includes one or more individuals, governments, governmental agencies, political subdivisions, labor unions, partnerships, associations, corporations, legal representatives, mutual companies, joint stock companies, trusts, unincorporated organizations, trustees and trustees. Let's continue. 6. Exhaustion. Let's pick this up at the top. Williams petitioned defendant DCS for redress on February 19, 2018 and Hamilton County on February 27, 2018, and both his requests for adequate administrative remedy were ignored. 45 CFR subsection 303.11 denied Williams' First Amendment right to petition the government for redress due to 45 CFR subsection 303.11 case closure criteria. His grievance form is attached with the case law right here. Let's read the case law, what he quoted. It states, there is no constitutional violation and no subsection 1983 action when there is an adequate state post-deprivation procedure to remedy a random arbitrary deprivation of property or liberty. Then it states defendants deprived Williams of his state post-deprivation remedy and now converts this cause of action into a constitutional due process and deprivation claim. Now, do you guys understand what I just said? Let's go over it again. Here states defendant deprived Williams of state post-deprivation remedies and now converts this cause of action into a constitutional due process of deprivations claim. How is that possible when this has everything to do with a domestic relations issue, okay, which the federal courts cannot hear? You simply proved above that this has everything to do with child support, and you simply proved above that they were acting in their scope of duty, not outside of their scope of duty. So this is nowhere near a 42 1983 claim. Okay, but let's continue. It states, subsection 1983 is now the only vehicle which to assert his civil tort claims into constitutional injury, because there is no available state remedy to assert his rights and property interests. His due process claim does not fail, and his deprivation claims cannot be dismissed for failure to state a claim. Okay, but his claim will be dismissed for failure to state a claim because, as I just stated before, he proved that all defendants was acting in their scope of duty, and he also proved that this is a domestic relations claim dealing with child support, and those two arguments alone will get the case thrown out. Why? Because federal court, again, cannot hear domestic relation claims, and all parties are acting inside their scope of duty, which clearly states that once they're acting in their scope of duty, then underneath their scope of duty, they are immune from suit underneath the 11th Amendment. Okay, so now this is the end of page 4. Let's go to page 5. Like I tell you, it's like a 15-page complaint, even though it say 26 pages, but it's a 15-page complaint. Number 7, nature of complaint. This court takes notice that this is not a complaint about a judgment or decree for financial support for his offspring, but this court will take notice that it is, in fact, an argument of child support, basically stating that you bought this suit because they claim that you owe child support and you haven't been making support payments, so they put you in jail. Everything they're doing in their scope of duty, and because they're doing it in their scope of duty, they fall into the 11th Amendment immunity, which will be granted, by the end of this case, which we will go over after they make the ruling in the order, okay? Like I said before, guys, this is only video part 1. We're going to go over this entire claim. We're going to go over the entire case to see what's happened and what has taken place in this case, okay? So let's continue. It states, it is based on the fact that the defendant voluntarily, deliberately, and with premeditation under color of non-positive 42 U.S.C. Public Health and Welfare Codes, depriving Williams of his life, liberty, and property without due process of law, and then deprived him of his inherent and indefeasible rights, privileges, and immunities secured by the Constitution and the laws. Therefore, this suit is not barred under RCRA. But the suit is in fact barred under RCRA for the simple fact of the matter is what, guys? The simple fact of the matter is that he's suing them in their official capacity. He haven't proven how they caused them injury outside of their scope of duty. Okay? And it's just that simple. But let's continue. Number 8, color of law. PL 93-647 of the Social Security Act offer billions in profit to the defendants for 4D activities. See Rehut versus Ledbetter. Has nothing to do with anything, but let's continue. It states, although state participation in the Social Security Act itself is mandatory, participation by the state in the 4D program is voluntary. Defendants were created under the 4D of the Act. By contrast, the U.S. Title 42 Public Health and Welfare Codes is a non-positive law title. Title 42 is comprised of the Social Security Act that was editorially compiled and organized into title, but the title itself has not been enacted into positive law. The distinction is unconstitutionally significant because non-positive law titles are prima facie presumed evidence of the law, but positive law titles constitute legal evidence of the law in all federal and state courts. 1 U.S.C. subsection 204, but that again has nothing to do with anything because they're using prima facie, which is presumed evidence of the law, to proceed forward. You have not rebutted any of the presumptions, not even in this complaint. You see, that's why it's looking bad for this cat already. But let's continue. Title 9 states private business operations. It says defendant carefully tailored 4D scheme is administered by a single and separate organizational unit to oversee this complex federal state 18 U.S.C. subsection 1961 4 enterprise, created the federal OCSE assistant secretary for the administration of children and family, who reports directly to the secretary of the DHHS, who is charged with overseeing defendants' compliance with their federal approved plans. We already know that already, but what do this have to do with the complaint? It has nothing to do with the complaint. And like he said, Congress created the federal OCSE. Okay, we know Congress is what? The legislator. So if Congress is the legislator, we know that in order for him to sue them underneath federal rules and statutes and codes, the Congress or the legislator must do what? They must waive sovereign immunity. There is no code where it states that the legislator waives sovereign immunity to sue the agencies and its employees when they're acting inside of their scope of duty. And also when they're dealing with a domestic relation issue. That's not there. And he can't prove that. And because he can't provide that or prove that, this case will automatically get thrown out as well. So this is page 5. Now let's go to page 6. The 4D program is a partnership between the federal government and the state within the meaning of 28 U.S.C. subsection 3002-15A. United States means federal corporation. Then he says, see Franconia Association versus United States. Then let's read this case law he quoted. It states, once the United States waives its immunity and does business with citizens, it does so such as the parties never cloaked in immunity. Okay, but the key word is, if you read it in its proper context, it says, once the United States waives its immunities and does business with citizens. Okay, so now he have to prove that the United States, in fact, waived its immunity, or he have to prove that the states, in fact, waived their immunities to be sued underneath 1983 when they're acting inside of their scope of duty, and you have to prove that Congress and the legislator both wrote that into Congress stating that they can be sued, which he cannot do. So again, this case will get thrown out. Let's continue. It states a corporation, therefore, being not a natural person, but a mere creature of the mind, invincible and intangible, cannot be a citizen of a state or of the United States, and cannot fall within the terms or powers of the above mentioned article, and can therefore neither plead nor be impleaded in the courts of the United States. That had nothing to do with anything, but let's continue. 31 U.S.C. subsection 6305 prescribed the mutual contract as the legal instrument reflecting the partnership that extended O.C.S.E. into Tennessee under the color of authority as an arm of the state. Oh, yes, we know that, and like I stated before, you cannot sue the arms of the state in federal court. They are also immune, but let's continue. When the United States entered into contract relations, its rights and duties therein are governed generally by law applicable to contracts between private individuals who are parties to such instruments. There is no difference. What do that have to do with your situation? Nothing. He still haven't stated the claim yet. And we on page 6. Let's continue. The subsection 3002-15A underwrites roughly 2/3 of the cost of defendants' 4D efforts. Subsection 655A, with a case law to support it, it states to ensure the sale of corporate bonds and similar securities to the public by agreeing to buy those which are not sold. This has nothing to do with anything that he's complaining about. I don't know. Like I tell you all, he's all over the place in his complaint. Let's continue. And 4D contract is a mutual binding legal relationship obligating defendants to provide 4D activities and to perform administrative duties of the CSD in return for payment. 45 CFR subsection 303-107C. These contracts are relevant because they obligate the defendants to assistance the CSD in carrying out the program. The defendant publicly advertised that its 4D program provides services that promotes parental responsibility to meet the financial needs of children and their families through its 4D program. However, that was perjury. Like I said, man, this man's argument is all over the place, but let's continue. The requirement that a state operates its, let's go to page 7, its child, hold on, it says the requirements that a state operates its child support, let's go to page 7. Program in substantial compliance with the Title 4D was not intended to benefit individual children and custodial parents. You have a case law to support that, but let's continue. Like other states which has voluntarily agreed to participate in the AFDC program, states are required to offer child support services as a condition of receiving federal funding. Again, this has nothing to do with his complaint. I don't even know why he's mentioning any of this BS. It seems like he's just taking up a lot of paper, and trying to stretch out his argument, but his argument haven't stated the claim as of yet. But let's continue. The defendant used their website on the internet to improve customer service. Again, what does this have to do with anything? But let's continue. Customer service is the provisions of service of customers before, during, and after a purchase. The priority assigned to customer service is relative to product and pricing as a important role in its ability to generate income and revenue. Okay, again, how is this affecting your situation? It says C.U.S. DHHS web-based customer service for parents. Their vision is to lead in effectively partnering with human service customers. Customers focus and trust their customers and partners for additional assistance to call their customer service or fill out a customer inquiry form. A customer is a buyer, purchaser, or patron. Again, that has nothing to do with anything, but let's continue. It states this is relevant because defendants must charge a $25 application fee and a $25 annual user fee to applicants. These fees are the fifth stream of profit. Again, what does this have to do with stating the claim upon relief can be granted? I still haven't figured it out yet, guys. Like I said, this complaint is all over the place, but let's continue. Therefore, the Tennessee 4D program is a private business. Then it states affecting or belonging to private individuals as distinct from public generally. Then it says not official, not clothed with office, activity which benefits corporations, organizers, or members. Then it states wherefore 4D activities are not constitutional in nature. They are ex contractu, Latin for from a contract, the legal term that indicates the consequences of a contract that denotes the source of a legal action. He used Black Law Dictionary to support the definition, but let's continue. It is much in the nature of a contract in return for federal funds. Then it states the defendant did go in disguise as a state agency on the internet superhighway under color of non-positive Title 42 U.S. codes and 45 CFR for profit with the intent to intrude upon William's solitude and private affairs and to subject and cause him to be subject to. So again, guys, you can see we just finished the whole page 7 and he still haven't stated the claim upon relief. He still haven't established the claim upon relief can be granted. He's basically just all over the place with his claim, and his claim haven't stated any type of injuries being done to his so-called client known as James Frederick Williams. Again, this is why these cats are going to the federal court and losing, because they don't have a clue or understanding what they're doing. So now let's go to page 8. Let's pick this up at the top. I don't need to read that. That has nothing to do with anything. You go pause and read it for yourself. That's supposed to be a footnote, I guess, but let's continue. It states the defendant did subject Williams to the same offense and more than twice put him in jeopardy of life or limb, should I say, because of being subject to the above 4D activities within the meaning of subsection 1983, the defendant by operation of law and fraud. Then he has deprived him of his status of man. You all can read that. Pause the screen and read it if you like. Okay, then it states, wherefore there are multiple constitutional deprivations under this subsection 1983 claim because the defendant under color of non-positive 42 U.S. codes and Title 45 CFR customs and usage in this state, territory, or the District of Columbia subject and cause Williams to be subject with the jurisdiction to. Now, as you all can see, we're going to page 9, and he still haven't stated the claim upon which relief can be granted, and we're almost 9 pages in. You see, out of a 15-page complaint. Let's continue. Deprivations of his rights, privileges, and immunities secured by the federal and state constitution and laws, and did deprive him of life, liberty, and property without due process of law. But he still haven't explained how they did any of that. But but like I stated, let's continue along with this long complaint filled with nothing. 10. Statement of facts. While serving time in federal prison, Williams was employed by Unicorp, making $1.25 per hour. Soon after he began working, his honestly acquired income of $200 per wage were immediately garnished for 4D collections by defendants without due process of law, and he was denied his Fifth Amendment due process safeguards required by defendants. PL 103-66 C CFR subsection 303-101 C2 and 466-42 U.S.C. subsection 666A3A procedural due process requirements. After Williams was released in February 2003, every paycheck he honestly earned was garnished by the defendants. After a thorough investigation, Williams questioned defendants who revealed that the order was a default judgment because he failed to respond to notice and appear in court to establish paternity. Now you see why I tell you all to respond back. If you do not respond back, they will do what? They will default you, okay? But Williams is arguing his claim in the wrong court. He's arguing his case in the wrong court. He should have took that portion and argued in where? State court. Argued in the same court that brought the default judgment in against him. But let's continue. It states, however, the defendant never once notified Williams, FCI Manchester, or FCI Ashland of a pending child support lawsuit. The default order provisions apply to paternity as well as the current support order establishment as the enforcement case was worked via expedited process. Then it states the defendant order provisions apply to paternity because without paternity establishment, the defendants would have no legal claim on Williams' honestly acquired income as the support order establishment and enforcement case, which was worked via expedited process. To expedite the case process, a judge surrogate was given authority to enter the default orders, which did not possess the same force and effect under state law as orders established by full judicial procedures. Again, why haven't you stated that in state court? Why are you in federal court stating that? Has nothing to do with federal. Again, let's continue. Cause of action, Fifth Amendment violations. Then it states the two threshold questions in this subsection 1983 claim for denial of due process are whether Williams possessed a liberty or property interest protected by the Constitution or federal statutes, and if so, what process was due before he could be deprived of that interest and property. Okay, so now as you all can see, we just finished page 9. He still haven't really stated a claim upon relief to be granted, especially in federal court. Let's go to page property and income which Williams honestly acquired. He retains full control of, subject to these limitations. First, he did not use it to his neighbor's injury, and that does not mean that he must use it for his neighbor's benefit. Second, that if he devotes it to public use, he gives the public the right to control that use. And third, whenever their needs require, that they may take it upon payment of due compensation. That had nothing to do with his situation, guys. Again, he haven't stated a claim upon which relief can be granted as of yet. Let's continue. Wherefore, it is a valid Fifth Amendment constitutional violation and deprivation under subsection 1983 because Williams did not use it to his neighbor's injury, nor for his neighbor's benefit. He did not devote his honestly acquired income or property to the defendant's use, and he did not grant them the right to control that use so that whenever their needs require, they may take it upon payment of due compensation, and as such, he is now deprived of his life, liberty, or property without due process of law or fair procedures. But they gave him a right to speak. They gave him a duty to speak. He kept sending the mail back probably like the father-in-law tell you. Tell you guys to. If you keep sending the mail back, but I tell you all, they will default you. And because they defaulted him, he should have handled that in state court. But obviously he didn't handle it in state court. And when he did decide to handle it in state court, they found him in contempt. And once they found him in contempt, guess what? He did the jail time instead of challenging the original support order like I tell you all to do. Challenge the final order. It's just that simple. Now let's go down to the first cause of action. Number 1. Cause of action and claim under relief 42 U.S.C. subsection 1983 against defendant DCS. Defendant 42 U.S.C. subsection 654.3, single and separate division of child support voluntarily engaged in an act of collusion depriving Williams of his rights under the 8th and 14th Amendment of the United States Constitution. And 42 U.S.C. subsection 1983. Defendant acted under color of law, color of office, and color of authority not granted by the United States or state's constitution in the performance of their contractual duties and engaged in conducts with malice and reckless or callous indifferences to Williams' constitutional and statutory rights, thereby causing the injury and damages. Again, this has nothing to do with stating the claim. The guy is all over the place with this document, but let's continue. And it's pissing me off. Let's continue. The routine use and disclosure of Williams' Social Security card number and account number to subject him to non-positive 4D collections activities for profit creates a claim for damages against the defendant for using his name and likeness, which is his property, for their benefit without his permission. The act deprived Williams of his Fourth Amendment right to secure his person, house, papers, and effects against unreasonable search and seizures without a warrant showing. So again, we just finished page 10, and guess what? He still haven't stated a claim upon which relief can be granted. Let's continue. Now I see why they're going in these courts and losing. Let's continue. Probable cause, particularly describing the person or thing to be seized, was violated. Cause number 2. Cause of actions and claim for relief 42 U.S.C. subsection 1983 against defendants 42 CFR subsection 302-34 Hamilton County states what? Defendant engaged in an act of collusion that deprived Williams of his rights under Article 1, Section 9, Paragraph 3, the 1st, 4th, 5th, 6th, 7th, 8th, 9th, 10th, 13th, and 14th Amendment of the United States Constitution and 42 U.S.C. subsection 1983. Defendant acted under color of law, color of office, and color of authority not granted by the United States or state constitution in the performance of their contractual duties and engaged in conducts with malice or recklessness or callous indifferences to Williams' constitutional and statutory rights, thereby causing the injury and damages. Again, guys, haven't stated the claim as of yet. Let's continue. 42 U.S.C. subsection 302.34 proves 1. The existence of the municipal policy, customs, and practices. 2. The policy, customs, and practices contributes to the deprivation and violations of Williams' federal rights. Again, he hasn't proven anything as of yet. He's just throwing out conclusionary statements. But let's continue. A municipality or other local government may be liable under subsection 1983 if the government body itself subjects a person to a deprivation of rights or cause a person to be subject to such deprivations. Again, he still haven't proven any of that in his claim. Okay, but let's continue. Williams' 1983 claim against Hamilton County is not barred by the 11th Amendment. Yes, it is. Why? Because they are acting in their scope of duty. This guy just don't get it. That's why all his clients continue to lose in federal court. But let's continue. Holding local government entities, including counties, are not protected by suit. Not protected from suit by the 11th Amendment. Number 3, cause of action. And we're at the end of 11 pages. Still haven't stated the claim publicly can be granted. Out of 11 whole pages, he haven't stated the claim. Let's continue. Cause of action and claim for relief underneath 42 U.S.C. subsection 1983 against defendant, 45 CFR subsection 30234 Hamilton County Sheriff's Department. Again, we're at page 11. 11 pages of nonsense. He still haven't stated the claim yet. Let's continue on. Let's go to page number 12. Defendants engaged in an act of collusion that deprived Williams of his rights under Article 1, Section 9, Paragraph 3, the 1st, 4th, 5th, 6th, 7th, 8th, 9th, 10th, 13th, and 14th Amendments of the United States Constitution and 42 U.S.C. subsection 1983. Okay, guys, just to give you all the head up, he's going to be saying that through the rest of these paragraphs that he posted, okay, for each defendant. But let's continue. Defendant did voluntarily enter into a 45 CFR subsection 302.34 4D contract with the DCS to provide services of process, including warrants for arrest that target only individuals subject to 4D activities in return from payments from DCS. Said warrants, arrests, and collections benefit the Title 4D program as well as the sheriff Title 4D contracts as well as the $28.5 million payroll cost. Again, this has nothing to do with his complaint. I don't know why he put that up there, but let's continue. Defendant acted ex contractual under color of law, color of office, and color of authority not granted by the United States or the state's constitution in performance of their contractual duties and engaged in conducts with malice and reckless or callous indifferences to Williams' constitutional and statutory rights, thereby causing the injury and damages by falsely arresting him and depriving him to CCA against his will. So again, the fraud of law has not stated a claim upon which relief can be granted. So now let's go to number 4. 4. Cause of action and claim for relief. 42 U.S.C. subsection 1983 against defendant, 45 CFR subsection 302.34 Hamilton County Clerk of Court Division. Defendant engaged in an act of collusion that deprived Williams of his rights under Article 1, Section 9, Paragraph 3, the 1st, 4th, 5th, 6th, 7th, 8th, 9th, 10th, 13th, and 14th Amendment of the United States Constitution and 42 U.S.C. subsection 1983. So again, I know it all sounds repetitive and redundant, guys, but I'm just reading the claim exactly how he provided it, okay? So you all can see how he lacks in his writing skills and how he lacked in stating the claim upon which he can be granted. But let's continue. Defendant did voluntarily enter into a 45 CFR subsection 302.34 4D contract with the DCS to provide the duties of a clerk of court that are initiated by the DCS that only target an individual subject to 4D enforcement in return for payments from DCS. As clerk, the officer can only exercise constitutional duties and powers conferred upon clerks of court generally, which role is almost exclusively clerical, and laws or orders of the court strictly define the powers exercised. This office failed to discharge the duties of the office diligently, honestly, impartially, and courteously. All right, we had cause number 5 at the end of page 12, and we still haven't stated a claim upon which relief can be granted. So now let's read cause 5. Number 5, cause of action, claim for relief, 42 U.S.C. subsection 1983 against defendant, 45 CFR 302.34, Magistrate Audrey Jones and Magistrate Chris Gotti. Let's scroll down. Defendant Jones and Gotti, in an act of collusion and malfeasance, deprived Williams of his rights under Tennessee Constitution, Article 1, Section 18, Article 1, Section 9, Paragraph 3, the 1st, 4th, 5th, 6th, 7th, 8th, 9th, 10th, 13th, and 14th Amendment of the United States Constitution, and 42 U.S.C. subsection 1983, defendant subject Williams for the same offense and twice put him in jeopardy of life or limb and issued multiple void warrants for Williams' arrest under oath without probable cause, and did cause him to imprisonment for debt in a civil case under the guise of contempt of court for non-payment or not paying enough. This deprived him of his rights to secure his person, houses, papers, and effects against the unreasonable searches and seizures. Okay, let's continue. Defendant Jones and Gotti did voluntarily enter into a 45 CFR subsection 302.34 4D contract with the DCS to provide for the magistrate services that are initiated by the DCS and only target individuals subject to 4D enforcement in return for payments from DCS. Case also support that. Again, still haven't stated a claim upon which relief can be granted, but let's continue. It is much in the nature of a contract in return for federal funds. The state agreed to comply with federal imposed conditions. Subsection 1983 bars any actions brought against a judicial officer for an act or omission taken in such officer's judicial capacity. However, Jones and Gotti were not operating in their official capacity, but due to being under contract to perform the duties of the DCS, was acting in private contractual capacity only. Like I said, man, haven't stated not one claim, but let's continue. An officer who acts in violation of the Constitution ceased to represent the government. Let's continue. A judge ceased to sit as a judicial officer because the governing principles of administrative law provide that the courts are prohibited from substituting their evidence, testimonies, records, arguments, and rationale for that of the agency. Additionally, courts are prohibited from their substituting their judgments for that of the agency. When Jones and Gotti became clerks for DCS, masquerading as judges, they walked away from any immunity that they may have presumed and become personally liable. Okay, so again, we're at the end of page 13, and they still haven't stated a claim upon which relief can be granted. Okay, he's trying to make it seem as though these judges are not acting as judicial officers, which is far from the truth. They're acting in their magistrate capacity, which is also immune from suit. Then that's why he's losing. Let's continue. Let's go to the next page. Judges loses absolute immunity from damage actions only when he acts in clear absence of all jurisdiction or performance of an act which is not judicial in nature. When enforcing mere statutes, judges of all courts do not act judicial and thus are not protected by qualified or limited immunity. Again, they are acting in their scope of duties, so again, they will be covered. But let's continue. Jones and Gotti, clerks while masquerading as judges, committed treason by authorizing an unlawful terrorist extortionist ransom demand upon Williams and a seditious conspiracy in concern with DCS, CA, Maximus Child Services, and case manager Stacey Elrod, ex-all, etc., pursuant to federal codes. When a judge acts where he or she does not have jurisdiction to act, the judge is engaged in an act of treason. It has nothing to do with nothing. Let's continue. Cause number 6, guys. So again, let's continue reading. Cause of action and claim for relief, 42 U.S.C. subsection 1983 against defendants Maximus Child Services, defendant Maximus in an act of collusion contracting deprived Williams of his rights under Tennessee Constitution, Article 1, Section 18, Article 1, Section 9, Paragraph 3, the 1st, 4th, 5th, 6th, 7th, 8th, 9th, 10th, 13th, and 14th Amendment to the United States Constitution, and 42 U.S.C. subsection 1983. Defendant did voluntarily enter into a contract with the DCS and Hamilton County to deprive 4D incarceration services that are initiated by the DCS and only target individuals subject to 4D enforcement in return for payment from DCS. Maximus Child Services, Inc., under corporate citizenship, is partnered to defendants and held Williams prisoner for over 12 months against his will and specialized 4D coercive incarceration services, including jail intake, enforcement, and collection that target only individuals subject to 4D activities in return for payment from CSD. Remedy of due course, guys. Again, we have 14 pages in, and he still haven't stated the claim upon which release can be granted, guys. So that's why I'm saying this case can get thrown out, because again, he's throwing out blanket statements and conclusionary arguments. But let's continue. Remedy by due course of law. Okay, let's continue, guys. Let's pick this up at the top. We almost finished. We're on the last page. It states, there is a factual nexus between the defendant who deliberately and with premeditation deprived Williams of his due process rights that resulted to the injury and damages from which he now suffers, which is now remediable by the defendants. State and family law must do major damage to clear and substantial federal interest before a plaintiff can demand intervention of a federal court. Okay, let's continue. He did what? Jury trial demanded. So basically he's doing what? He's demanding a trial by jury. Let's read it. Plaintiff hereby demands trial by jury on all claims and issues so triable. So again, I'm making this video to find out will he actually have this trial, or will they throw this case out before then? That's it. That's all. You all can read the prayers and relief if you want. I'm going to read the first paragraph, and I can, you can pause the remainder. It says, wherefore, because the plaintiff acted fraudulently in this case, and to set right this undesirable and unfair situation, this court should enter judgment Williams' favor to terminate 4D collections case number and alleged arrears effective immediately, and they have the you all can read the damages that he want to get paid for. As you all can see, he signed it with his name. That's it. Okay, so again, guys, we're going to see if these cats who's going to these federal courts are going to win or not. Like I tell you all, man, stay out of these federal courts. I can't stress this enough. This whole claim, haven't stated a claim upon which relief can be granted at all. This case will be thrown out. So the next video we're going to put up is what? The next video, which will be part 2, will be dealing with the motion to dismiss that the state or that the defendants put in when defending against this argument. Okay, so again, that's all I'm gonna do for today. If you all need my help, hit me up in my email at y'allismagnified@gmail.com. Let's see if the fraud law gonna be 0-2 or 2-0. I'm banking it gonna be 0-2, man. Anybody want to take any bets, man? I'm taking all wagers to see, man, which one he gonna be. I'm saying gonna be 0-2. He's gonna lose both his clients' cases who he came on and had speak on his channel. And I asked him, after he lose or after they lose, will you bring them back on so they can explain what happened and why they lost? I bet you it'll be the same reasons why I told you guys that they will lose underneath Federal Rules of Civil Procedures 12B1 and 12B6. But again, that's all I'm gonna do for today. You all be blessed. Like, share, and subscribe. With that being said, I say shalom.